I mean, as I recall, we were talking about blood gushing from the nose, but we never had any evidence of that. So really what I was basing my recommendation on was the bruising that she had suffered. So
from May, Your Honor, is that what
yes,
you're referring to?
yeah,
All right. Understood.
yeah.
The point remains, though. We are alarmed having read this, but also not surprised. This has been Mr. Mortensen's approach from the very beginning of this case. Deny, deny, deny. No acknowledgement or ownership whatsoever of his acts of violence. I'm going to use a metaphor. It is very imperfect, so bear with me. But let's think for a minute of their respective mental health journeys as a race. The assessment and the treatment recommendations, those are the starting gun of the race. Taylor's running down the track. She's made progress already. She's taking ownership. She's taking actual concrete steps. Dakota has not even started the race because his assessment is so one-sided and does not include anything that could, that points to his culpability in this story. And he has plenty of it. That's why in our filing from last week, you would have seen, Your Honor, that we are essentially requesting a redo of his assessment. This time, and we're not asking for anything more. She just wants Dakota to provide the same collateral information to his assessor that she provided to hers. Pretty basic, I think. He simply was not open or honest in his assessment as DCFS requested the parties be. And that's a perfect segue.
Was he? I mean, I don't know how much this is driven by the assessor too, in terms of what the questions that they're asking. They're not the same person, it doesn't look like, right?
Yeah, Your Honor, I do take issue with counsel.
Let him finish first. Let him finish first.
Of course.
We'll come back. We'll come to you.
So, Your Honor, a lot of the assessment is narrative, what Mr. Mortensen has reported to the assessor. And so that's what I'm basing it on. I don't see any indication that he was forthcoming. And that's what I would have expected from the court's May 6th ruling. And that's what DCFS has explicitly indicated in terms of their preference. There was a team meeting. Now I'm segueing into a few comments about where DCFS is at, Your Honor.
Right.
There was a team meeting, separate team meetings in this case due to the protective orders. A team meeting on May 27th. Both parties in this case have filed DCFS's 8-page summary of the child and family plan. And to summarize, it gives both parties a handful of items to be working on, and both sides are in progress on each item. The main exception from our perspective is that Dakota is not really undertaking the assessment in an appropriate way. So those, in terms of where things are at, I'm happy to also address some of the arguments that they've made regarding social media and missed parent time. I can do that now, or I can hold off until Mr. Hall speaks. What would you prefer, Your Honor?
Well, I'd like to know where you're going. I think I can anticipate that you're wanting a restoration of the terms of the stipulation.
Exactly right. There are a couple main allegations made in Mr. Mortensen's filing from last week. Some social media posts by my client, as well as some missed parent time. I want to address those arguments now. And then
I wanted them to be addressed as well. And I also wanted to address the allegations that maybe there was parent time that was canceled or missed.
Sure. No problem, Your Honor. As to social media first, either the court should give his arguments zero weight, or the court should give both parties some instruction regarding social media practices during this case. If we look at docket number 96, this is our supplemental briefing that was filed a few days after the hearing. This is an Instagram comment.
In which case?
This would be in the within case, in the Mortensen matter, Your Honor.
The one where he's the petitioner or the respondent?
The petitioner, Your Honor.
Okay. All right.
So again, docket number 96, final page there. That is an Instagram post made by Mr. Mortensen the day after the hearing on May 1st, where he tags our witness, Ms. Jessie Draper, and publicly ridicules her using profanity. He also mentions Taylor by name. I interpret this to be intimidation and harassment of a witness, something Taylor has not done. We think the court should be concerned about both of these women being named in his post. The integrity of the proceedings are compromised if Dakota is allowed to publicly disparage a witness who went out on a limb to provide the court with valuable information regarding the proceedings. If, for instance, after today's hearing, Dakota went on social media and used profanity to let's hypothetically lay into Dakota's therapist, the court should rightly be bothered by that. And so we think that this was inappropriate. There's also another leak after the April 30th hearing in which Dakota leaked a voice memo to TMZ, yet again designed to embarrass Taylor and the aforementioned witness. More media circus, more unwanted attention on the parties and their child. And to use his words from the May 28th filing, when he makes his social media argument, I actually think, ironically, this conduct on Dakota's part shows a concern regarding his mental health and impulse control. Yes, Taylor did chirp at someone online. This is a former friend who she felt diminished the terrible ordeal she has been through, especially the abuse by Dakota. But she didn't tag Dakota, didn't rip into one of his witnesses as he's done. As far as
Well,
misparenting,
did she disparage him in the postings at all?
there's, if you read the postings, she's certainly talking about her journey, and Dakota has interpreted that as being kind of indirect disparagement. But we've got this delicate balance where she wants to use discretion, but she also feels that it's an important part of her journey to document her healing, so to speak. But no, she's not directly laying into him.
Well, that's the main concern I would have. I mean,
Okay.
these are people that have effectively made their private lives public right into the thick of popular culture. And I don't want to restrain them necessarily from their rights of free speech, except to the extent that it might adversely affect the welfare of the children. So if we're talking about disparaging others, that is one thing as opposed to disparaging each other, something that the child might eventually be able to see, and it might affect the child in the long run. So as you know, we have standard types of restraining orders against making denigrating, derogatory remarks directly to or in the presence of children, dissuading third parties to do the same, and then including or in public forums, including social media. That's not an uncommon type of order that we would have. Not trying to restrict them from their right to engage in social media, but only to the extent that they may be denigrating each other.
Understood. I appreciate that additional direction. I think both of these folks will benefit from that clarification, Your Honor. As far as missed parent time is concerned, my client wants every minute she can get with her son ever. A few of the visits over the last month or so have been cut short or have not taken place, and there are a few examples or a few reasons for doing so. A recent example is the child was extremely ill. I believe it was with hand, foot, and mouth disease, which is awful.
Cold sore breakout.
A cold sore breakout.
That was addressed through counsel, right? You talked about that.
Yep. As far as Mother's Days, the Mother's Day visit, the long Mother's Day visit, that was cut a little bit short because of limited supervisor availability on that day.
Okay.
There's also some difficulties and ongoing challenges regarding just coordinating schedules with supervisor availability.
All right.
As far as our request today, you already know, Your Honor, you touched on it. We're asking for lifting of supervision as well as a return to normal custody and parent time, what was agreed to in the August 2025 stipulation. Supervision's not designed to be permanent. It's appropriate to lift it now because safety concerns have ebbed and are being addressed in a comprehensive way with both parties. Remember, there's safety concerns with both parties, and both parties are currently addressing those with DCFS. Really cannot describe at all how difficult it's been for both my client as well as Ever to endure this separation over the last 2.5 months. Not to mention Ever's two older siblings. These are two children that my client shares with her ex-husband, Mr. Paul. We have 3 extremely confused, hurt children who need to be back with each other. She successfully co-parents with her ex-husband, shares custody of the 2 other children. And again, the sporadic and very short visits have been difficult on all 3 of them. This child, Ever specifically, does not understand why this is happening, why these visits end so abruptly. And she's in a difficult situation where, again, abruptly ending these visits has been extremely challenging for Ever. And so she has a decision of moving forward, hell or high water, with every single visit, no matter what, knowing that they may be traumatic for the child or unduly difficult for the child, depending on the day, or hold off on some of the visits, knowing that Dakota will use that against her and try to portray her as unmotivated or disinterested. But that's just not the case here. Ever is her entire life. She's been his primary historical caretaker almost his entire life. They signed, as Your Honor already knows, a comprehensive settlement agreement in August that awarded most of the time with Ever to my client, about a 70-30 split, roughly.
Mm-hmm.
There was a brief interruption last fall when my client was filming The Bachelorette with ABC, and Dakota did have, during that period, more time than what was allotted in the agreement. It was a temporary period. Since the April hearing, my client has purchased a home. She has plenty of space for her and the 3 kids. This signals stability on her part, stability that all of her kids, including Ever, will benefit from. On the other hand, it's not really clear how or if Mr. Mortensen can provide for Ever. He's not currently working. He labeled himself as a stay-at-home dad in his assessment. We're not aware if he has any income. It says he used to own and operate a tile business. Not really
I
sure
think
what he does.
he filed a financial declaration in the domestic case, right?
And I don't have that in front of me, Your Honor. I'm just going from what I think is even more recent, the assessment, where he reports financial information in that to the assessor.
Okay.
Mr. Mortensen, aside from having kind of a black box when it comes to income, he has nowhere near the same support network in Utah that Taylor has.